Your brother, Mr. Justice Chacha MUITE, your brother, Mr. Justice Mugambi, your brother, Mr. Justice Mwongo, sitting separately, each one of them was persuaded that the petitions and the notices of motion asking for conservatory orders raised weighty constitutional issues. That is why this bench was constituted. Those weighty issues await full arguments by both sides for the court to resolve. Number two, the weighty issues are around the petitioner applicant, the deputy president, challenging and seeking to have the impeachment quashed. In the interest of time, I will not restate those weighty issues. They are in the record before, but they are there. Challenging the impeachment and seeking to have the impeachment quashed. For the sake of this country, today and going forward, those are issues that must be heard and adjudicated by a bench that has no issues of bias, apparent or real, being raised against. So for that reason alone, please accede to recusing yourselves so that another bench can be set up to adjudicate on those issues. I thank you.
Very briefly, Your Lordship. My name is Kirago Aduta. I would like to talk about just three aspects on the subject of recusal, and I'll be making reference to three materials. I believe they've been circulated, but a recent Supreme Court decision delivered on 11th of October 2024. Let me make arrangements so that they are brought, the copies. Yeah. Your Lordship, on my right and on my left are counsel who are involved in this matter where the Supreme Court was asked to recuse itself.
Which case?
This is Dari Limited and 5 others versus East African Development Bank. Mr. Nyamondi and Senior Counsel Paul Mito on the same side, but today they are on different sides of that decision. When that application was made before the Supreme Court, I do not want to go through all what went on. I want to go straight to paragraph 27, where the court said, having arrived at the inescapable conclusion that we are being accused of bias and working towards an undisclosed predetermined outcome, we are strongly persuaded that our further participation in these proceedings will not serve the ends of justice, at least in the eyes and perception of the appellant/applicants. Consequently, and inevitably, each of us of this bench does hereby recuse him or herself from further participation in the hearing and determination of the appeal dated 25th April 2023 and filed on 26th April 2023. My Lord, that's a decision that was made just when these petitions were ongoing. So, when allegations of bias and working towards a certain outcome are made, what the Supreme Court recently is it recused itself. My Lord, I have a decision, an Indian decision. It's called the State of Punjab versus Davida Pal Singh, which also the question of recusal was discussed at length. And again, I do not want to dwell. The whole decision is a very lengthy one. It's about 400 pages. But at page 9, at paragraph 16, the court set the standard that is applied in determining whether a bench should recuse itself. And the test, I read, the test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and whether the adjudicator was likely to be disposed to decide the matter only in a particular way. The court went on to say, the court has to proceed observing the minimal requirements of natural justice, i.e., the judge has to act fairly and without bias and in good faith. A judgment which is the result of bias or want of impartiality is a nullity, and the trial coram non judice. Therefore, the consequential order, if any, is liable to be quashed. Lastly, and this is what is very important, at paragraph 18, the court said in part, however, if there is real ground for doubt, that doubt must be resolved in favor of recusal. So that, my lord and my lady, if you are in doubt whether you should recuse yourself or you should not recuse yourself, that doubt should weigh towards recusal. That decision will be shared. And then the court went on to quash some proceedings which had taken place, an appeal had been determined, and then this one went all the way to the Supreme Court of India. So the court said that that is how situations of bias are treated. I had reference to the code of conduct of judicial officers. I think that's what Mr. Dego was referring to. My Lord, I want to lay the basis as to where those provisions are obtained from. And those provisions are obtained from the IBA guidelines on conflict of interest in international arbitration. You will find that material is published by the I located it from the International Bar Association, and it was done first in the year 2004, and it has been applied worldwide as a guide on determining situations of conflict of interest. And it has graded conflicts in several shades, the traffic light shades. There's green, there's brown, and there's the waivable, non-waivable, waivable, green, and the brown. And at clause 2.37, one of the situations that is a waivable conflict is the arbitrator has a close family relationship with one of the parties or with a manager, director, or member of the supervisory board or any person having a controlling influence in one of the parties or an affiliate of one of the parties, or with counsel representing a party. Going with the materials, if they are true, that were stated by my learned friends, then that situation has already arisen, and therefore it is a good ground for recusal. My Lord, I don't want to take much more time. These materials will be circulated. There is much more in these materials that speak towards recusal in the situation that is now before. Thank you very much, Mr. President.
Sorry, Counsel, does the court have the benefit of the authority that you have referred to, the Punjab case and the IBA guidelines?
The Indian and the Supreme Court case?
Yes, and the IBA guidelines, have you supplied?
They have been brought. Yeah, thank you.
How many more?